we are dealing with the longest succession battle in the history of Kenya. Mbiyu Koinange. The deceased was the first Kenyan to obtain a postgraduate degree. The first one. He died in 1981. His case was determined in the year 2017. This is a case that was so acrimonious. The dispute was that when Mbiyu Koinange died, 4 women appeared saying they were wives. And the question is, who qualifies to be a wife? Can the court dismiss somebody as not being a wife? Does your father have a mistress? Does your father have other women? Any property transferred by your father before he dies, it cannot form part and parcel of the estate for distribution. Wakili Dan Sanumari tells families, let us use alternative system, alternative methods to resolve family disputes. Over 40 years in court over the estate of a dead person. All these properties, Mbiyu Koinange looked for them. None of these people fighting for his property participated in the generation of that property. Why can't families sit and negotiate? Why can't families sit and have a cup of tea and discuss this matter? Welcome to Court Helicopter Explainer, where we are dealing with the longest succession battle in the history of Kenya. This is a landmark case that went over 40 years in the courts of Kenya. This is the case of the late Mbiyu Koinange. Let us look at the decision. The appeal went to the Court of Appeal, and this is a matter that is Civil Appeal number 47 of 2016. It was decided by Justice P.N. Waki, M.S. Asike Mahandia, and Mr. Justice K. Minoti, all of them judges of the Court of Appeal, on November 24th, 2017. What were the issues? Here in the judgment, the introduction of the deceased, very interesting. It says, the historian Brian Branch, in his book Kenya Between Hope and Despair, that is a book of 1963 to 2011, Yale University Press, notes that the deceased, Mbiyu Koinange, to whose estate this appeal relates, was a very influential figure in the first post-independence regime in Kenya. He was educated in the United States of America and the United Kingdom from the 1930s for his undergraduate and postgraduate degrees. Indeed, his nephew, the journalist JKL Live, Jeff Koinange, asserts in his autobiography, Through My African Eyes, Footprints Press, 2014. This is Jeff Koinange Live. The deceased was the first Kenyan to obtain a postgraduate degree. The first one. Every Kenyan had a bachelor's degree. He's the first person to get a postgraduate degree. The deceased played a major role in the anti-colonial politics in Kenya as founder member of the Kenya African Union in 1944 and served as its representative in London between 1951 up to 1959. Early in 1939, he was the founder of Kenya Teachers College, Githunguri, one of the first indigenous African educational institutions where he served as a principal until 1948. Between 1961 and 1962, he was the Secretary General of the Pan-African Freedom Movement for East, Central and South Africa. After independence, he was not only a close confidant of the first president of Kenya, Mzee Hayati Jomo Kenyatta, but also his brother-in-law. He is a brother-in-law. He's a sister of the brother to Mama Ngina Kenyatta. For a long time, he served as minister in Jomo Kenyatta's cabinet in the powerful docket of Minister of State in the office of the president, and therefore this is a big story. He goes on to say, the deceased acquired and accumulated massive wealth, particularly prime land in Kiambu, Nairobi, Nakuru, and Mombasa counties, in all totaling to almost 6,000 acres worth billions of shillings. Unfortunately, that wealth has turned out to be the apple of discord in his family, as vividly demonstrated in this appeal and the proceedings in the High Court that gave rise to it. Since his death intested on 3rd September 1981, he died in 1981. His case was determined in the year 2017. His family has known no peace, fighting acrimoniously over whom his dependents are and their respective shares of the property. The litigation over his estate has spawned countless petitions, objections, and applications for one relief or another, ultimately leading to this appeal. Even the deceased grandchildren and third parties have joined the fray, staking all manner of claims to portions of the estate. So the question that was in court is found in paragraph 6 and 7. What is it? There is no serious dispute regarding the beneficiaries. The dispute was that when Mbiyu Koinange died, 4 women appeared saying they were wives. And the question is, who qualifies to be a wife? 2 official married wives? One allegedly was a copy typist, a secretary to Mbiyu Koinange. The other allegedly was a worker to Mbiyu Koinange. So the question before the judges was, how do you decide who is a wife, who is not a wife? And how do you distribute the properties of this protagonist? This is a case that was so acrimonious. The 2 first wives are arguing that the 2 other wives are not wives. But Mbiyu Koinange died in the hands of the last wife, the one they called the copy typist, the one they called the secretary to Mbiyu Koinange. She is the one who took him to hospital. She's the one who laid the flower, the wreath of the flower, the first time at the grave of Mbiyu Koinange. In the eulogy, she was acknowledged as a widow. So the question the judges were looking is, if people are saying this is not a wife, and the people have been living together as a husband and wife, can the court dismiss somebody as not being a wife? 2, they said in the arguments that were in court that yes, she was married, but she was divorced. There was no evidence at all presented in court whether she was divorced. The arguments were heavy. What did the judges decide? Before we go there, does your father have a mistress? Does your father have other women? Is she married? Is your father married under African customary law? You hear the Court of Appeal, what the Court of Appeal decided, the landmark decision of the judges, paragraph 175. They said, ultimately, We answer the issues presented in this appeal as follows. Margaret and Eda are widows and beneficiaries of the deceased, and each of their houses comprises the widow only. So the two women who are being called workers were declared to be widows. 2. As a result of one above, there is no basis for an order directing them to refund payments already made to them from the estate of the deceased. The two wives wanted these other two women to refund whatever they had gotten from the state. The Court of Appeal rejected. 3. There is no evidence that Sylvia is a biological child and a beneficiary of the deceased. Among the people who were in court fighting that they are beneficiaries is a lady called Sylvia. She could not prove that she was a child of Mbiyu Koinange. She could not prove that Mbiyu Koinange ever supported her in her life, ever paid school fees, ever fed her, ever took her to university. She lost. Therefore, order 3, there is no evidence that Sylvia is a biological child and beneficiary of the deceased. 4. Kiamba stroke Wagudu 2334 is part of the estate of the deceased, is unavailable for distribution. If Eda elects to keep it, her share in the estate of the deceased shall be reduced accordingly. 5. The deceased share in Ocean View Beach Hotel were validly transferred to Eda and are not available for distribution. Because Mbiyu Koinange was living with Eda as the last wife, he transferred Ocean View Beach Hotel to her before he died. And they tried to bring that property into the estate. The court has always said, any property transferred by your father before he dies, it cannot form part and parcel of the estate for distribution. 6. Mudera Farm is part of the estate of the deceased and is available for distribution. 7. Tangulizi is entitled to 4.5 acres from Barbara's share in the title number Kiamba, stroke Limbigwa, stroke 819. 8. This matter is remitted back to the High Court for redistribution of the estate by a judge other than Justice Musyoka, J, to the beneficiaries of the deceased as identified in this judgment. For that purpose, the matter shall be mentioned before the presiding judge, Family Division, within 15 days from the date of this judgment for the necessary directions on priority hearing and determination. The estate shall bear the cost of the administrators, and all the other parties shall bear their own costs. Those were the orders of the judge. What are the lessons from here? Wakili Dan Sanumari tells families, let us use alternative system, alternative methods to resolve family disputes. Over 40 years in court over the estate of a dead person. All these properties, Mbiyu Koinange looked for them. None of these people fighting for his property participated in the generation of that property. Why can't families sit and negotiate? Why can't families sit and have a cup of tea and discuss this matter? Under the Constitution of Kenya, Article 159, alternative dispute resolution, mediation, arbitration, negotiation should be the way to resolve family dispute, so that you enter into consent and that matter is okay. This has always been our appeal. The way we appeal about burial disputes, that it doesn't pay to keep somebody in the mortuary and fight. The court's process are long. Okili Dan Sanomari, thank you and keep watching.